Good day. In this quick take, we're going to look at the attempted class action by Chris Underwood and a bunch of other individuals against Coinbase Global, Coinbase, and Brian Armstrong named individually, interestingly enough. This case stemmed from basically, again, not a lawyer, not a tax person, so always do your own research. This action was brought against Coinbase, alleging that basically Coinbase supported unregistered securities trading, and as a result, again, not knowing the backgrounds of these plaintiffs, they're bringing this action against Coinbase, and the impact is, beyond just what happens with these plaintiffs in terms of if they feel like they were wronged by Coinbase or they were allowed to do something they shouldn't have been allowed to do. The reason why I decided to do this as a quick take is because, 4 or 5 years ago at this point, I remember Mike Cagney, guy CEO of Figure, and I were talking, and he said that, look, in order for crypto to be widely adopted, and this is mainly, we were talking about asset-backed securities and his home equity tokens and all that, but just more broadly, it's really going to take a number of court cases to really define civilization's relationship and society's relationship with digital assets and crypto. Regulatory agencies from around the world putting out proclamations are sort of pickets or defense mechanisms, because obviously those regulatory agencies, whether they're in the US, whether they're in China, whether they're in Africa, whether they're in Russia, it doesn't matter. The fact is that those regulatory agencies are basically empowered and charged to defend and protect, right? And from a risk perspective, not doing something is always safer than doing something, with respect to the acceptance of cryptocurrency and digital assets. So these regulatory agencies that put out guidance that seems to sort of stop progress in its tracks are really just kind of like temporary hole patches for the regulators to not stick their entity or their country out while they wait for legislatures to make laws and for courts to make decisions. Now, legislatures making laws, I can't speak for other countries, but in the US, there's certainly a lot of lobbying and a lot of fiscal support that goes behind politicians, so that when they're deciding what to legislate, I'm sure somewhere in the back of their mind, there's either a direct or indirect bias to act in a way that isn't going to be detrimental to their capital raising, and take that for what it is. The other challenge is that, the courts, the actions that come out of the courts are really what matters, because when you have a law, right? So Congress can make a law, but then there has to be a body that enforces that law. And then when there's conflict arising from the enforcement of that law, that's when the courts get involved and draw on precedent and experience and analogy to say, okay, based on everything we know, facts and figures, this is the right outcome. And then that outcome is enforced. Oftentimes, the outcome of a legal proceeding is enforced with greater efficiency and effort than, say, the enforcement of a law, where there might be interpretation and concern that it's not being necessarily applied in the manner in which it was written. And that kind of, again, creates that circular nature of, well, that kind of leads to the court cases. So we really want to watch the courts, and I'll insist upon this going forward, that regulatory pronouncements and policies is very important for coming up with like the boundaries, right? If you're in bounds, don't go over here because that's out of bounds. That's where the regulatory guidance comes in. But it's the court cases that actually, those decisions, that interpretation becomes more the law of the land than the law itself. So without further ado, we're going to go through Judge Paul Engelmeyer's decision to allow for the dismissal, but not only that, and stay tuned for this because it's near the end, that there can be no further amendment of this complaint. So not only was this complaint basically thrown out, the plaintiffs can't come back and try again. So that's going to be very interesting to see what happens. So I'm going to go ahead and share my screen. Here we go. And excellent. This here is the legal brief itself. If you want to find it, just Google Coinbase Global Inc. Just these terms right here, or Chris Underwood, because how much stuff I don't know Chris Underwood from a hole in the wall, but I'm sure if you look up Underwood and Coinbase, you're going to get this brief. All right, all in the public domain. And that's one of the things I will say I really love about, I can't speak for other countries. One of the things I love about the US is that if something's brought to a court, barring it being sealed, all this stuff's available. And there's just a lot of good information in here. I always say words have meanings. That's why you got to look at those policy documents and the order they write things. This is no different, and even more so, right? Every single word carries the weight here. So in this case, it starts right out the bat that Judge Engelmeyer resolves a motion to dismiss a putative class action suit brought under federal securities laws against Coinbase. So this is important, right? One of the nagging questions since I've been in crypto, and even to this day, is are tokens a security or not a security? Well, the whole basis for this case is under securities law and under the Exchange Act. So even in this dismissal, I bet we're going to find out some really interesting things about the way judges versed and trained in securities law approach tokens in crypto, especially when we don't have a definitive language from the SEC per se about this fact. So the judge has to navigate some interesting waters here. So this is the amended complaint, and it alleges that among the assets that Coinbase enables customers to buy and sell are ones that the plaintiffs are saying qualify as securities, and they allege that there's actually 79 assets, and they call them tokens here. Again, one of the challenges with not having common nomenclature in this industry, people, is that it's called tokens here. In other places, they're called crypto assets and crypto this and digital markers. The champion that really locks in the term for cryptocurrency digital assets, I can't even do it myself, right there will be a huge de-risk when we all use the same word to describe the same thing. So it alleges that notwithstanding Coinbase practice of transacting in these securities with plaintiffs, Coinbase is not registered with the SEC. So basically they're saying, look, I went to Coinbase, I was able to trade securities, and Coinbase isn't registered with the SEC. Okay, so on this basis, that's let the plaintiffs here. There's a number of challenges, right? There were damages from Coinbase sale or solicitation. There was damage related to illegal contracts that Coinbase entered into its users to purchase and sell securities. So the complaint is saying that the user agreement, which comes into play as part of this dismissal, that the actual user agreement itself qualifies as an illegal contract to purchase and sell securities, and some more stuff. I'm going to scroll through this. If I didn't highlight it, it's because at the time I first read it, it didn't really jump out at me as something that was like interesting from a crypto perspective. And I'm not going to spend a lot of time on legal stuff here. I'm not a lawyer. So here you go. And basically here the court grants in full the motion to dismiss with prejudice and the state claims without prejudice. Again, those are legal terms, but here the court gets rid of both federal and state claims. They also talk about why they get rid of both at the end. Just for the sake of argument, or just in case I forget, it has to do with jurisdiction, and that basically state can have jurisdiction differently than a federal matter, but something about the order that they're settled in, and if there's not enough information to really warrant a certain state action from surviving this federal dismissal, then they'll go ahead with it. But in this case, the court did not find from the information presented, and it's more than high level, but they didn't find anything in the information that was presented that would warrant keeping a state claim open while the federal ones were dismissed, so it all gets dismissed. Here's a little background on crypto assets and the blockchain. And they talk about securities and cryptocurrencies. Again, if you're a fan of the space, it's always fun to read like a would-be layperson's interpretation, even an educated judge, on how they describe this stuff. It talks here about users having a public key and private key, also very good information if you're not familiar with it. And they talk about Bitcoin because everybody knows Bitcoin, and the ability to track and whatnot because it's all on claim. This is interesting. It talks about crypto exchanges, and because it talks about crypto exchanges, they actually parse centralized and decentralized right here, which is really forward thinking when you think about it. I don't think I've seen something from a official capacity published where they describe decentralized versus centralized exchanges. We know from the banking announcements that they don't tend to like decentralized exchanges. But here in a crypto exchange, let's see what it says. Decentralized. Okay, so decentralized they start with. That such exchanges may be analogized to Craigslist. Now, Craigslist, for the folks that are maybe not in jurisdictions where it exists, is just kind of like an old school yard sale, flea market type online Web 2 experience where you list something and then people can come and buy it. Decentralized exchanges don't actually hold any of the assets. They just provide a means for exchange between the different parties. That's the power of the DEX, right? That the DEX itself doesn't hold the asset. It just creates a marketplace where people can go and trade. In some cases, there might be some advertising revenue or a transaction fee. But the key point there is that decentralized exchanges do not hold assets. And that's great to see the court acknowledge that. Centralized exchanges play a more substantial role in the transactions. So it talks about users having to create accounts. The exchange provides the customer a deposit address. When the customer deposits crypto assets into the address, the exchange credits the trading account. The exchange will typically then transfer the assets into one of its other addresses for storage. So in essence, it's saying, look, a centralized exchange acknowledges the holding of the asset on the part of its users, but it's like bookkeeping, and the actual asset itself may be totally positioned or kept or stored somewhere else. And that's what got a couple of these exchanges in trouble, mind you, right? Where they actually took the customer's product and used it as collateral against other loans, which they in turn lost. And so a centralized exchange, the centralized exchange sits right in the middle. And so rather than letting two individual customers transact directly, that fact that the centralized exchange has to hold the asset is very critical for this case and crypto in general. So then it talks about the Coinbase's exchanges and that there's a platform and that it's active and that borrowers can buy and sell. AC means amended complaint. So as you're reading and scrolling through this, the plaintiff's complaint once didn't really take, they came back and amended it, and it didn't work this time for them either. So trades do not happen on the blockchain and do not actually involve the transfer of any assets between users. Instead, Coinbase faces both the buyer and seller. So if two users wish to transact, they basically transact with Coinbase in the middle. So Coinbase is actually acting as a settlement agent and clearing. That's not in this argument. Someone will probably bring that up later. Don't use this video as evidence. I'm just not a lawyer. But really, like if that's what they're doing, right, that's settlement. And that's also a function that's typically reserved for chartered banks and other entities that take fiduciary responsibility for collateral. Like I said, totally other issue. And then customers are charged fees. So Coinbase sits in the middle, and etc. So the AC's premise is that Coinbase lists and sells securities, but it's not registered as a broker-dealer. And it talks about how the plaintiffs purchased and sold tokens on the platform. At the same time, it wasn't registered as with the SEC as a securities exchange. So these are all the complaints. It also, it stands between the buyer and the seller, meaning that the exchange itself is the actual seller of the unregistered securities. So here the plaintiff is saying, look, I know I'm trying to buy from Ted, but if TED is selling its crypto, or it has its crypto with Coinbase, and Coinbase actually has title and control of it, well, when I go to buy from TED, I'm not really buying from TED as a seller. I'm actually buying from Coinbase, which again plays into this whole broker-dealer securities thing. Here's the class action. There's procedural history. Skip ahead. Very interesting motions. You can actually look up all these documents and see kind of how the language worked out. This is now focused, though, on the dismissal, because that's what ultimately happened. They ultimately chose to dismiss. So the judge goes in here and talks about the standards for governing the motion to dismiss. And basically, to survive the dismissal, the complainants have to provide enough facts to state that the claim is plausible on its face. And in this case, the judge is clearly saying it didn't. The first was that, and this is right at the initial part of the discussion, the very first claim that the Coinbase violated something under the Securities Act, and then those are in the Exchange Act, is based on a single premise that the tokens are securities, right? So in essence, if Coinbase were to have irrefutable proof that the token was a security or was not a security, then there's no violation, right? But we know how the market works. We know that Coinbase hasn't proven that tokens aren't securities. No one has. And we know the SEC also hasn't come out and mandated specifically, hey, all of these tokens are securities, and here's why. There's like the onesie, they're the ongoing court motions, the ripples and the settlements and stuff. This is the big surprise that I hope gets settled in this decade. But right there, right, the complaint alleges that each of the 79 tokens is a security. Which makes, they're saying it's an investment contract. And look, they even quote the Howey test here. The plaintiff talks about why they say they're securities. Again, the court probably would not want itself being pegged as the entity to decide whether that's true or not, but that is part of the outcome here if the matter does move forward. So if there is another challenge against Coinbase, as a broker or securities dealer, and that judge doesn't dismiss the case, and that does, move beyond settlement, when that case is decided, clearly that decision is going to create precedent for whether to treat crypto as a security or not. So judges are very cognizant of this. And unless there's an activist judge that really wants to decide on the matter, and have the world and Congress and everyone kind of deal with the repercussions of that, until that goes ahead, most judges are going to try to stay away from this third rail issue. Okay, the token was introduced to the public, losing transactions. So right here, the judge even admits here, like, were the case to reach summary judgment, the contention that the 79 tokens were securities would be central to it. But the defendant, so in this case, Coinbase, and presumably because whether the tokens are securities presents a question of fact litigated as summary judgment, the court need not address this issue for the purposes of this motion. So in a way, Judge Engelmeyer sort of sidesteps the issue. He acknowledges that central to the case is whether or not these tokens are securities or not, right? Like, that's what he's saying, is that it's central to this case. But it's not central to the dismissal. Central to the dismissal is a function of, as it said above, have the plaintiffs demonstrated why the dismissal shouldn't occur? Has enough evidence been provided in relation to the actual complaint to warrant the dismissal? And this notion of whether or not a token is a security or not is not the only kind of critical issue to address. So this judge is saying, we're going to go look, and we're going to go elsewhere, and we're going to look at other elements of the complaint first, and really in this case only, to take this question of a token being a security or not off the table altogether. So kudos to this judge for dodging this bullet, but at some point there will be a reckoning. So this is so right here. I'm scrolling up just so here's the discussion, right? So it talks about the investment contracts. It talks about why the judge isn't gonna talk about tokens as securities, and then it goes right to the claims under the Security Act. Okay. So under the Security Act, it talks about the offer and sale of unregistered securities. The plaintiff must show that no registration statement was in effect at the time of the issue. The defendant sold or offered securities. Mails were used in connection with the sale. There's also a private right of action for the purchaser against the seller in any transaction. So there's all sorts of like rules and regs around buyers and sellers of securities and the rights they have, and they define in this idea of statutory seller, where is the individual passes title directly to the buyer, or if there's like a remote purchaser involved. Very technical, very technical. So in summary, the plaintiffs can recover from the defendants if the defendants were the direct sellers of the token, or the defendants actively solicited the sale of tokens to plaintiffs or did so for financial gain. Okay, so this is basically what they're saying, is that did the defendants directly sell the tokens to the plaintiffs, or did they actively solicit the sale of the tokens for financial gain? Those are going to be the 2 points that things get hung up on here. What's interesting is if you kind of scroll through, the other thing the judge calls into question is the fact that in this amended complaint, the amended complaint throws out the original user agreement with with the customers, and makes its argument based off of the activity and the operations of the Coinbase platform, which is actually different than what the actual user agreement says, and it gets covered a little later. So it says here, but plaintiff's bid is complicated because the amended complaint above allegations repudiate diametrically allegations in the original complaint in an apparent attempt to evade dismissal. So Judge Engelmeyer here is saying, like, look, I know we don't go into the original complaint that much here, but I'm telling you, the original complaint talked a lot about this user agreement and some other things, and then the amended complaint literally just tried to dodge everything that the original complaint was challenged on, and clearly the judge did not appreciate that, because why else call that out? But it does play a fact later, right? So here it talks about a party cannot advance one version of facts, right, and then amend pleadings to incorporate safe in the belief, right? And that's what they say here, that basically the complaint painted a different portrait of Coinbase with factual allegations that undermine the amended complaint's thesis as a statutory seller. So again, technicality, but the whole way the complaint was framed and then amended really shot the plaintiffs in the foot here. Okay, the complaint's factual allegations about who holds title to the tokens are also at issue. So again, who holds the title and who's the actual seller, quite important. Skipping ahead, because again, it's a lot of background and chatty chat on legal stuff, right? Now, here it says, I highlight this as being important. The user agreement flatly contradict the amended complaint's allegations that Coinbase holds title to the digital assets. So the users sign a digital agreement with Coinbase. Full disclosure, I use Coinbase in varying capacities. So I do have some inherent bias here. I'm trying not to convey that. I honestly don't remember my user agreement. I probably just clicked it and then went off. But apparently the user agreement states that the digital currency shall always be with the person, the customer, and not transfer to Coinbase. And it even says, again, you control the digital currencies held in your digital currency wallet. That is clearly, patently false. Coinbase takes control of your assets. So the user agreement, and the reason why it's brought up here is because I guess in the original complaint, the original complaint looked at the user agreement and made all these arguments, based on the user agreement. But then once the actual operations came out as being like, look, you don't have a relationship with Coinbase like the user agreement states. At that point, the amended complaint had to like pull back from referencing the user agreement and look more like old school, like securities law. And the judge here is like, no, you can't do that. You can't rely in your original complaint on an argument that comes from the user agreement and then come up with a whole new thesis for a complaint that excludes the basic premise of the initial complaint. So I think that's kind of cool, but I also kind of think like, I think a more practical reality is all the stuff should be considered. Not a lawyer, not a judge. The user agreement reinforced the complaint's pleading that by using Coinbase, the user does not transact directly with the Coinbase entity. It states when you buy or sell digital currency on Coinbase, you are not buying digital currency from Coinbase or selling digital currency to Coinbase. So Coinbase acts as an agent transacting on your behalf. So that's what the agreement says, but we know that operationally is not what's happening. And in fact, this is where the judge is like, look, you strategically added some facts here to help your complaint. Not pleased with that. And that's big. I'm going to keep scrolling down because that's kind of like the big punchline of this first piece is that, look, you can't amend the complaint. Plaintiffs argue that the amended complaint adequately alleges that Coinbase solicited plaintiffs' purchases of tokens. Because this is the other half. So the first part of the dismissal was, look, the user agreement, which you predicated the complaint on, is different than the actual way Coinbase operates. And just because you amended the complaint to point out that fact, you can't throw out the user agreement thing. So kind of all those matters should be rolled into one. But that contradiction is enough of an issue for the judge to be like, not good. And again, remember, the burden's on the plaintiffs to show why they shouldn't dismiss the complaint. The second piece here is the plaintiffs argue that the AC adequately alleges Coinbase solicited plaintiffs' purchases for tokens. So this is kind of the classic thing, like broker-dealers cannot solicit, actively like go out and be like, hey, come buy this stuff, you'll make a bunch of money, when they're getting money themselves, right? That's kind of like they have a perverse incentive at that point to kind of sell whatever because they're getting paid for it. So there's that wall that says, if you're a broker dealer, you can't solicit, more or less. So the court in this one case says, when a person who urges another to make a securities purchase acts merely to assist the buyer, not only is it uncommon to say that the buyer purchased from him, but it's also strange to describe the giving of gratuitous advice, even strongly or enthusiastically, as soliciting. So here, Coinbase helps people buy stuff so that if Coinbase puts on its website something like an advertisement from one of these tokens about like, hey, why you should buy it. I'm interpreting here, but it's almost like saying, look, Coinbase gets paid when you buy, gets paid when you sell, and they of course are motivated to see people use their platform. But it should not be considered soliciting when they're not directly benefiting from the sale or purchase of that asset. They may benefit from the activity of selling and buying, but if they're just assisting you by making you aware of this thing that you can buy, and their compensation isn't tied to the active, like, hey, you need to buy XYZ coin now, then it's strained to call that relationship soliciting. So in essence, if you are a broker or broker dealer and you are, here you go, you support the buying and selling of an asset that you have access to, merely raising awareness around the fact that you can get this stuff here falls short of soliciting. Obviously, if they're getting some sort of reward on the sale of the stuff, different story. Now they're fundraising, then it's soliciting. And not a lawyer, but that's kind of what I'm interpreting this judge is saying, is that you really can't hang it on to onto Coinbase, that they allowed people to buy these things and call that soliciting. That's just them serving the token foundations or entities doing its job. So it also said that even had the amended complaint pled direct solicitation by Coinbase, it does not plead that the plaintiffs purchased and sold tokens as a result of such solicitation. So not only is it incumbent upon the plaintiffs to demonstrate that the platform for buying and selling securities was actively advertising and soliciting because of some financial benefit they stood to gain, but in addition, the people that did the buying and selling would have to provide evidence that they did so at the behest of Coinbase, that it's not just about Coinbase soliciting, it's also I'm reacting to the solicitation. So that is something to that's very interesting here to hear about. And the judge is basically saying the plaintiffs didn't do it. The plaintiffs did what they did, regardless of this so-called solicitation. All right, claims under the Exchange Act. This was going back to the original piece. It talks about illegal contracts, because the illegal contracts in this case have to do with like voidable contracts because of the fact that it involves a security. The challenge here is that the amended complaint keys its allegations on the first element, a contract involving a prohibited transaction, to the theory that tokens were prohibited. Basically here they're saying, look, they argued that they were in a contract that involved the purchase of an illegal thing, right? So the purchases and sales at issue in this action constitute individual contracts that are voidable. Well, the challenge here is that the contract in question are two different things. From the judge's perspective, the user agreement is the contract that would be challenged as potentially being voidable. But remember, the user contract doesn't say anything about you buying and selling securities from Coinbase. So where would Coinbase's transgressions vis-a-vis the Security Act align with the user agreement, which is saying you're not actually dealing with them? So that whole relationship, again, needs to be reconciled in the complaint. Something to the effect of okay, here's the user agreement, here are all the operating ways that the user agreement is being followed, and then the kind of what then becomes voidable, again, beyond me, you'd have to somehow kind of bridge these two gaps. So the first question is the contract involved in a prohibited transaction. Well, the user agreement doesn't do that, right? So the parties disagree as to the contract implicated. The plaintiffs take a transaction point of view that they argue each transaction is in and of itself a separate contract between me and Coinbase. So the plaintiffs in the amended complaint are saying, well, there's no user agreement. What they're saying is, look, every time I went to Coinbase and logged in and I made a promise to exchange and blah, 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 that is a contract that I entered into, and that's the one that she needs to be voided. Whereas Coinbase, of course, is pointing back to the user agreement and saying they signed an agreement, and that's the contract. So the plaintiff, the judge here actually makes this is actually super important, right? It says the plaintiff's notion that each transaction involving one of the tokens is a contract lacks factual support. So, and in this case, this is semantics. The lawyers for the plaintiffs did not identify any transaction-specific contract. So there are ways they could have tried to do that through screenshots and pop-ups, etc., but they must not have done that, and so therefore it was out. And it said, here the court confronted substantially the same issue in a similar fact pattern between investors made purchases or sales against the backdrop of a foundation. So in this case that they're referring to, which look at the name. So in the case they're referring to here, for precedent, they're saying, here's a case where a buyer and seller entered into an agreement with another party to make these trades. And so were the individual trades that buyer made voidable contracts, or was it that universal agreement with, in this case, Bernie, the thing that was voidable? And so right there, the judge is like, I can't rule over something where the plaintiff and the defendant are totally they're not in agreement as to what the voidable contract is. And that kind of falls on the plaintiff to make it crystal clear that this is the contract that we are considering void, and this is why. The only contract capable of rescission is the user agreement, which they leave out, right? So the judge is like, gone. And scrolling ahead, control person liability, state claims. This is the one where it's like, why did the judge throw out all the state claims? This is where it talks about original jurisdiction and the need to like maybe have a state specific claim remain for some fact or circumstance. But in here, the judge is saying there's nothing that makes me believe that the federal matter versus the state's matter, there's any difference, that some rule under one of these states would somehow hold up to the dismissal claim. And more information. And here is the court accordingly declines exercise supplemental jurisdiction. The claims are dismissed without prejudice. And I think if I keep here, they say revising the complaint isn't going to overcome the factual averments. I don't know what that means, but I'm going to say that's like missing stuff. And that the amendment would be futile, which is great. So for the reasons above, the court dismisses all the claims with prejudice and the state claims without prejudice. All right. So we covered a lot of ground in this motion. Again, read through it yourself. So what did we learn, right? So in summary, from our perspective, what we learned is, one, the judges that are brave enough to actually handle these matters and bring them forward are going to be calling on both plaintiff attorneys and defendants attorneys to be very specific and complete in their initial filings and their defenses of certain motions, and their count and the defense team's filing of motions have to be very specific in how they support factually terms and languages they're using. So if they're using a term like contract, then, and the contract in this case is the contract formed by the user, pressing a button, as opposed to a contract being formed by the signing of a legal document, well, then screenshots, code, etc., need to be used so that a judge can look at things on its face and go, yeah, okay, that's a contract. I understand the transaction. That's the concern. Let's go after it. The securities issue is going to continue to be a problem. This Judge Engelmeyer, wisely, tactically, slyly, smartly, was able to dodge the securities issue by basically saying, look, there's enough other problems. I'm paraphrasing. There's enough other problems with the complaint to warrant the dismissal that I don't have to deal with the securities issue, but someone will. And that's going to be very interesting to see how they deal with it. I would say I do like a lot of the clarification provided on, like, hey, in a centralized exchange, you are giving up control of your stuff to this entity that doesn't have to have insurance. They're not a bank. They're not a custodian that comes with insurance. And so when when you think about the safety of your stuff, keep that in mind. Like, you are basically handing your stuff over to a company, no different than you would be giving, $100 to McDonald's to hold on to, and just be like, all right, when I come back for the $100, McDonald's, go ahead and give it back to me. So I hope you found this insightful and interesting. Please feel free to join and subscribe, leave comments, reach out to me, Howard Krieger. I'm on LinkedIn, and stay tuned for our next quick take, where we'll see what starts to percolate up from the regulators in terms of trust or tax or what have you. But whatever it is, we're going to cover it here. Thanks again, and have a great rest of your week.
Welcome to Unfederal Reserve,